Okay, good afternoon, everyone. I am Nathan Howe. I'm an attorney with K&L Gates, and on behalf of the Northeast chapter of the EBA, it's with great pleasure that I welcome you to this discussion of FERC's year ahead. Although our speakers require no introduction, we're incredibly privileged to have three distinguished panelists here with us today, all of whom have previously served as commissioners at the Federal Energy Regulatory Commission. Here with us are former Chairman Neil Chatterjee and Joseph Kelleher, and Commissioner Nora Brownell. Since we're all eager to get to the discussion, without further ado, I'll hand things over to our moderator, Rich Hydorn at RTO Insider.
Thank you, Nathan. As mentioned, I'm the editor of RTO Insider, LLC. We began covering PJM, if you're not familiar with us, in 2013. RTO Insider now covers all 7 of the RTOs and ISOs in the US. A couple of years ago, we added ERO Insider, covering the Electric Reliability Organization, NERC, and the regional entities. And then a year ago, we launched Net Zero Insider, which covers federal, state, and local efforts to address and adapt to climate change. So having level set my perspective, let me now introduce the panel. Former Chairman Neil Chatterjee served on FERC between 2017 and 2011. He served a brief stint as chair in 2017 and then again in 2018 through 2020. Former Chairman Joe Kelleher served on the commission from 2003 to 2009 and was chair from 2005 to 2009. Commissioner Nora Meade Brownell served between 2001 and 2006 and overlapped with Chairman Kelleher between 2003 and 2006. So we have some very experienced and knowledgeable panelists here to talk about what the commission is likely to be doing in the next year. I am looking at a blank screen, and I'm not sure if everybody else is looking at that also, so I apologize. Let's start off with the discussion of the ANOPR on transmission planning. In July, FERC voted 4-0 for an advance notice of proposed rulemaking on transmission planning, cost allocation, and generator interconnections. In October, we saw more than 165 comments on the ANOPR, most of them agreeing with the Commission on the need for changes to aid the transition to a low-carbon grid. But there was no consensus over issues such as whether the Commission should eliminate participant funding or create independent transmission monitors. And transmission owners used the docket to call for restoration of incumbents' right of first refusal. Commissioner Glick said yesterday at the NASIO conference, that's the National Association of State Energy Officials, that he hopes to see a final rule by the end of the year or the beginning of 2023. So I'll post this to you. Does that sound feasible? And what is this rule likely to look like?
I can start, Rich, if you don't mind, just since I was there in July, and I'd just like to start with the caveat that I deliberately did not participate in the July ANOPR because I knew my term at the commission was coming to an end. And honestly, it's such a significant issue area and focus that I didn't want to preclude myself from potentially engaging on the matters in my post-FERC life. Look, it's a big deal, and I applaud my former colleagues for attempting to tackle it. To be candid, I had hoped to tackle transmission reform during my tenure at the commission. There's broad agreement that Order 1000 isn't working the way that it was initially intended to, but that's where the agreement stops. The moment you start to talk about what to do to potentially reform and open up ways to look at interregional planning and cost allocation and difficult siting decisions, interconnection issues, integrating new technologies, it just gets very, very challenging. And so my team and I came to the conclusion a couple of years ago that it would take so much bandwidth and so many staff resources that it would have inhibited our ability to complete other parts of what we had before us, like finalizing FERC Order 2222, or moving forward with PURPA reform, or the policy statement on carbon pricing. And so we tried to look at narrow, targeted ways to address transmission. trying to bring some certainty to the commission's approach to ROE methodology. And we had a transmission incentives rulemaking. But in many ways, I think we cleared the decks during my tenure at the commission and have freed up Chairman Glick and my colleagues to take this on. And it's exactly the right thing to do, but it will not be without its challenges. And I think the fact that it's, they've been working on it since the ANOPR posted in July, and that Chairman Glick acknowledged it'd probably be the end of the year or even into 2023 before it's completed. It just goes to show you how complicated a process it will be. Unclear to me how they'll proceed, whether it'll be one big rule or whether they'll break it up. And I think they were off to a great start collaborating with the states with this joint FERC-NARUC task force, of which there will be a second meeting coming up at the NARUC meeting next week in Washington, D.C. I think the fact that they're coordinating with state regulators is essential. And as part of the delicate balance that will come into play here. But there's many complexities that they're going to have to contend with. One of my last acts as chairman in October of 2020, we had a technical conference on offshore, and just the data that came out from that technical conference and the complexities about just simply interconnecting offshore wind to onshore are so complicated that in and of itself, which is a very small part of this broader effort, is incredibly time consuming and complicated and difficult. And so this is my long-winded way of saying I'm glad the commission is tackling this. It's very ambitious. It will not be without its challenges, and I'm very interested and excited to participate and see how the process plays out over the next year.
Joe, I mentioned that it was a 4-0 vote, but you've pointed out that a couple of the commissioner's statements almost read like dissents.
Sure.
So,
thanks.
Get your perspective.
Yeah, let me back up a little bit and just talk about an agenda. To what extent, how does a commission and a chairman think about when they're setting an agenda? And I always thought that's roughly 85%, just a figure in my head, 85% of FERC's workload is driven by filings that come in the door that you can't anticipate. And you need to respect that if you actually want to act in a timely manner in high quality orders and avoid a backlog. So that leaves you some room for a discretionary agenda, 15% or so. 15% is plenty to accomplish a lot if you're very efficient in what you propose. If you put forward crisp, a word our friend Pat Wood would use, a crisp proposed rule that's well focused, well thought out, well written, pretty that you resist trial balloons, you don't issue trial balloons, and you think of the end game. You think of like where might the commission end up at the end of this process? What's our legal authority? What kind of record do we think we'll have? And is there agreement among the commissioners? Because you really, in a perfect world, want unanimity or a super consensus at least. I would think most members, the general public wouldn't really care about things like backlog, quality of orders, and timeliness, but I think members of the EBA would care about that. And I think FERC should care about it. It mattered to us when Nora and I were there. And I think FERC is actually not very timely now in many respects. If you look at how long do initial decisions sit at the commission level before the commission acts now versus 10 or 15 years ago. If you look at how quickly does the commission act on complaints, what's the quality or lack of quality of hearing orders? I mean, I think making things worse is really unattractive, I think. So if you look at, and the ability to execute efficiently, there's variables in that. What's the stability in commission leadership? What's the stability in the commission's composition? And are the commissioners a group that have worked together? Are they fairly cohesive? Have they worked together? Can they work together well on big things? Now you take that prism and apply it to the ANOPR. I first of all don't really recognize it as an ANOPR. In my view, it really was a notice of inquiry, because an ANOPR actually proposes something. And when I was reading the ANOPR, and I did read the whole thing, the phrase "seek comment" kept on appearing. And I did a search for it. That phrase appears 185 times, and frequently asking 5 or more questions. So to me, using dumb math, 185 times 5, that's almost 1,000 questions. So to me, the ANOPR doesn't really propose something. It seeks comment. It's looking for answers. It's not proposing something. Also, the scope of it is incredibly broad. I mean, it doesn't address open access, but if you add transition incentives to the mix and add competition to the mix, because some of the commissioners have been talking out, well, should we have more? Should we introduce competition into the scope of the ANOPR? The scope of the ANOPR might be broader now than it was in July, and it was almost soup to nuts transmission issues then. Okay, then if you look at is the timing in the world of the possible? I went back, and if you look at what the ANOPR is touching, it's really reforming 4 landmark rules at FERC: Order 890, Order 1000, Order 2003, and Order 845. And just looking back, thinking, well, how long did it take to do those big landmark rules? And then it's a little daunting about whether the commission can meet its current schedule, because the average time from the first step to a final rule, the average time was 23 months. So 2 years to go from first step to last step. That's assuming there's a first step is either an ANOPR, a petition for declaratory order like 845, or request for comments like an Order 1000. So on average, it's taken 23 months. It's taken a maximum of 34 months in one case, and the fastest of the rules was 17 months. And that was Order 890. Nora Sudine and I were there. We had worked together for a long time. We had the same view in mind. There were not separate statements. The ANOPR, as Rich pointed out, had 3 separate statements that all 4 of the commissioners signed on to. 2 read like dissents or partial dissents, but it's frankly hard. If you view the ANOPR as an NOI, it's hard to dissent from an NOI, right? It's hard to dissent from asking a question, even if you think the question is ultimately out of the commission's jurisdiction. So I end up thinking, I find it, looking at history, it's impossible, frankly, for the commission to issue a final rule by December or January, I think. Just looking at the scope of the rule and how long it's taken to do comparable, how long it's taken for the commission to act in the very same areas the commission wants to reform. So I think it's either going to take longer, or the scope has to change, it has to be narrowed, or it perhaps has to be broken up into different orders. And there might be super majorities, because that should be the goal rather than 3-2. There should be, hopefully there's super majorities for discrete parts of it. And then those parts can move faster than the rest. So those are my practical observations.
Nora,
Can I add some?
I was just going to ask you to go ahead. Go ahead. No need for me to prompt you. You're ready to jump in.
Thinking, given the current set of circumstances that we face, I hearkened back to Bill Massey's comment when this started, and that was, it's time to be bold. One could argue we are not really getting environmental, economic, or equity outcomes that meet the threshold that we've learned to expect. We have a transmission grid that is old, that is vulnerable, that is not achieving what we need to do to deliver a grid for the future. If we want electrification, if we want renewables, we need to take every step possible to strengthen a network that is really critical to delivering us to a zero carbon future. Will there be consensus? Good heavens, no. We're in a cost plus business model that is unlikely unsustainable for the future. And I think we need to look forward to that. But I think we also need to consider $1 billion in weather-related climate outages, several $1 billion of congestion costs and power quality issues. These affect our economy, these affect people. So yeah, it's pretty uncomfortable, particularly for a traditional regulatory body, but I think it's time that we change the way we do business as regulators, because we can't keep up, and that ends up with a lot of market distortions. When you look at the queues, we're wasting money, we're delaying projects. When you look at the planning process, when 95% of the outcomes of the planning process end up dealing with what the utility wanted, I think that defeats the need for innovation and competition. So I'm thrilled that they're laying all these out for discussion. Now, will they do it in one big fell swoop? Probably not. I think the chairman has already said that they will break it up into sequential issues, which makes sense to me. And I think it would be great if they could get to unanimity, but when you have people who may believe it's their job just to disagree, maybe that's not possible in today's world. I think it's a different culture. And I also want to say one thing about the staffing. There's been an enormous amount of staff turnover. There's lots of open positions. I think we all need to be arguing for increasing hiring. We need to be supporting the efforts to recruit people, and we need to give them the tools that they need in order to do the job. I think they are critical to a future in building a fit for purpose grid. And I look at what's happened in Germany. I look at what's happened in Europe this summer. And I think we need to step back and say, how do the pieces fit together if we really want to end up with this zero carbon future? So I know it's aggressive, and I know it's uncomfortable, and I know it's not traditional, but I think it's time for non-traditional solutions.
Let's talk a little bit about the dynamics on the 11th floor with the new commission, new 3-2 Democratic majority. How do you see this aligning? Because putting aside even the constituencies that will be in FERC's ear on the transmission issue and other issues, there's also the dynamics of the individual commissioners, and we've just had Commissioner Phillips join us. Another open question is whether Chairman Glick will be reappointed when his term expires in June. And then there's the impact of COVID. Commissioner Chatterjee, you were talking about how infrequently you got to see your fellow commissioners in recent months. Maybe you can jump off on this first, Neil.
Yeah, absolutely. Look, I think Chairman Kelleher made an excellent point when he talked about to achieve complex things at a multi-member bipartisan regulatory body. It helps to have some cohesion and to be able to work together on things. And, you know, for a while there, at least for myself and now Chairman Glick, you know, we spent 4 years together. And while we had plenty of disagreements, we also got some things that pretty significant done together because we were able to figure out how to work with each other, had developed that trust level and understanding of what each of our particular approaches were, and our staffs got to know each other really well. When you look to this current iteration of the commission, Commissioner Danley, albeit was the general counsel for a number of years, but really, you know, he got sworn in I believe it was March of 2020, and you know, we went to full telework almost shortly after. I actually never sat at a public open meeting with Commissioner Danley during the entirety of our time serving together on the commission. And so he has adapted into his new role, transitioning from general counsel to principal almost exclusively remotely. Then you add in the fact that Commissioner Clements and Commissioner Christie weren't sworn in until the end of 2020. And neither one of them have really been able to come into the building and get acclimated. And yes, we're all sort of adept at virtual communication these days, but so much is lost in that process. And when you're trying to negotiate something as complex as reforming transmission policy, it's hard to do it virtually. Commissioner Phillips, you know, brand new, sworn in, obviously working, you know, in a virtual environment. But it's not just the principals, it's the staffs on the 11th floor who need to interact and work with each other. And then they also need to interact with senior staff. And I got to tell you, some of the critical meetings that are necessary, you know, in pre-agenda and, you know, some of the weekly meetings that staff has that are so essential to moving the commission's work before it even gets to the 11th floor. That's now all being done virtually. And when you're not in the room and you're not able to, you know, read people's reactions and interface, and now everyone's kind of multitasking in these virtual big gatherings, it has an impact. And so Chairman Kelleher, I thought, accurately laid out all of the, you know, substantive obstacles to getting an outcome on the timeline that the chairman has laid out. When you add in this variable that really none of the 5 of them have ever worked in the building at one time together, their staffs are having to get to know each other virtually, and they're having trouble interacting with the senior staff because of these circumstances, it definitely throws a twist into it. And to the extent I chafe a little bit when people talk about the partisan dynamic at the commission. Look, I was guilty of it. I certainly have acknowledged that my initial foray into FERC in the fall of 2017, I struggled to make the transition from partisan legislative aid to independent regulator, and I regret that. I think I came around, hopefully, in most people's eyes, and did the job in an independent manner once I got acclimated. But, to the extent that, sort of partisan political influences are being injected into the commission's work, it makes it that much worse when you can't be in the building together to talk through things face to face, rather than, have it virtually. It was most played out in kind of dramatic fashion at the May open meeting last year, that we all participated in virtually, and it got kind of contentious and heated, and there were amendments being proposed on the fly. And I don't think that happens if we're all meeting in the room together. There's something about virtual communication where it's easier to be more pugilistic than when you're in a room with people. So apologies for the long statement here, but it's something I feel pretty strongly about. I dealt with it for a year and a half during my time at the commission, and I know it's something that my former colleagues are wrestling with right now.
Joe, what kind of coalitions do you see potentially building within the 5 commissioners?
I don't think I'm close enough. Some of them, I don't have a good enough read on what their views are on certain issues. So I don't think I'm in a good position to handicap that. I think there's 3 votes for issue A, and these 3 for A, and a different 3 for B. I don't think I'm in the right position.
Nora, do you have any observations on that?
Yeah, I think the dynamic changes with the addition of a new commissioner. And while I can appreciate, and don't disagree with Neil about the challenges of COVID, I don't think the partisanship is as a result of that. I think it's a reflection of what's happening in the larger world. I'm hoping that they can get through that. I can tell you the entire time when we had lots of different configurations, we never ever got into a politically partisan fight. God knows we had food fights on a lot of issues, but it wasn't driven by politics. So I'm hoping that the commissioners collectively can look at the oath that they took and say, we are an independent body and we need to view forward. COVID makes it tougher, but listen, billion-dollar enterprises are being run the world over. Innovation is happening all over. I think if others can do it, I think the FERC can step up and work. Again, it's tough, but it's tough for all of us. And I don't look at that as a reason not to move forward and not to get to some consideration. If everybody does their homework and everybody has a lot of conversations, I think they can get to a better place.
To your question, Rich, about potential coalitions that could emerge, I'm looking really closely at Commissioners Christie and Phillips. They actually have greater familiarity with each other than they probably do their other colleagues, even though they're relatively new. Christie a year, Phillips a couple of months, because of their time, not just at NARUC, but at MACRUC together. And I think they're both coming from that state regulatory background. I think they view the world in similar ways and their approaches will be similar. And so I'm looking very closely to see how they work together. I also think it's interesting, Commissioner Christie and Commissioner Clements have been, kind of aligning on themselves on certain things over the past few months. And I'm interested to see how that dynamic develops. And then look, Chairman Glick has been doing this for a long time now. This is his 5th year on the commission. He knows how to count votes. He knows how to, see where things are going and try and build cohesion. So you could see, those 4 kind of working together. Commissioner Danley, it'll be interesting to see. He has a pretty strict interpretation of the law, and I respect that. And I could see him having real concerns about the commission overstepping its authority, which might make it more difficult for him to participate in depending on how far the commission goes. But I think the other 4 could very well come together to work on this.
Can I add one comment, Rich? I mean, I agree with Neil's comments about how COVID and Zoom hurts the interactions. Because when I was there, we would meet every week. When I was chairman, we'd meet every week, one-on-one, no staff, and we would talk about big things that I thought the commission had to act on in the next 3 months. And I'd usually kind of say, here's issue one, and here are 3 options. I like A, I could live with B, C I really don't like. What do you think? And a lot of times they wouldn't have an answer on the spot, but we wouldn't do something big unless we knew what's the center of gravity and is this a productive exercise? And then once we knew, then the order be written up versus writing up an order, flinging it down the hallway virtually and then seeing what the reaction is. It's just much more efficient. And then it could be that maybe there's a super majority on something and there's 1 or 2 votes for something else, and then you have to decide, do you split it up or not? But I think it does hurt that you don't have the one-on-ones that were extremely productive and avoided wasting a lot of staff time and allowed the commission to move quickly on things, because you got a high-level consensus at a policy level, and then you could write in the detail.
Before I move on to our next question, I just wanted to let our listeners know that they can pose their own questions in the Q&A box at the bottom of the screen. So we welcome those questions. Hopefully we'll have time to get them in. Let's move on. Joe, you've said that consensus among RTO stakeholders is less important than consensus among the commissioners. Can you elaborate on that? And then I have a follow-up, Nora.
That was an undemocratic statement I made in the prep call for this. I actually thought, to me, I don't expect wisdom or consensus to come from any stakeholder process. All I would expect is that issues are ventilated to the benefit of the commission. But I guess when I was at FERC, I always thought, many people on the call probably know of Edmund Burke and his speech to the electors of Bristol. And I always thought the role of a FERC commissioner or chairman was sort of like the role Edmund Burke laid out of what's the role of a member of parliament. And he basically said a member of parliament serves the people, but he does so by exercising his best judgment on behalf of the people. And that if he substitutes their collective judgment for his, he betrays the people rather than serves them. And I always thought that's a perfect distillation of how a regulator should act. So I didn't want to betray the regulated community. So I would use my judgment, and my colleagues would use their judgment on their behalf rather than just counting heads. And I think of the worst filing I ever saw at FERC was a filing whose argument really was one conclusory sentence. And then there were 13 pages of triple-spaced signatories. So there was something like 300 heads or signatures and one ridiculous conclusory argument. And I was chairman at the time, and I told staff, I want to reject this as fast as we possibly can, because I don't want anyone on the outside to think FERC somehow counts heads, that the quality of the argument is what matters. And a quality argument signed by one obscure person would carry much more weight at FERC than a nonsense or garbage argument signed by 300 people. I remember one of the signatories was the Isaac Walton League of Hartford, Connecticut. I'm like, what do they know about electricity? Yeah, what do they know about electricity markets? Why should their view have a lot of weight? And fortunately, my colleagues agreed, and we rejected it with like neck snapping speed. And I think hopefully we sent that message.
Nora, you've said that you've been on the record in the past as being as despising the stakeholder process. Would you like to explain that very provocative statement?
I'd love to, and it's hard to be more eloquent than my distinguished colleague, Mr. Kelleher, but I think we have to consider what is happening in the stakeholder process. People are protecting their own self-interest. If I'm a utility, I want to keep my customers, I want to keep my monopoly. If I'm a renewable advocate, I want access to the grid, but I want it in a way that I want it. If I'm a consumer advocate, I presumably want to keep prices low without thinking of longer term consequences. And so you have these endless conversations wasting enormous amounts of money and consuming huge amounts of time that often get to the kind of conclusion that Joe referenced. I think there needs to be a better way. I think people need to be heard, but ultimately it is up to FERC commissioners to make the decision based on the facts and based on the record before them. And that involves taking some risk. You're not there to make friends. You definitely will be called on the carpet by somebody. But the important thing is to keep focused on what is the outcome that we need, what is the outcome that we want. And sometimes, again, the commissioners are in a better position to look at that broader view because they're not there to represent a special interest or a particularly political view of the world. So I'm sorry to say that. I do think everyone should have an opportunity to be heard, but I think that the way it's working now is a waste of resources, and resources that could be better put to finding solutions rather than reasons not to move forward.
Thank you for that.
Rich, can I make one quick comment?
Yeah, go ahead, Joe.
One thing I think FERC is good at historically is making hard decisions and knowing that they'll be controversial and there'll be criticism. And if I could change one thing about how decisions get presented to FERC, it would be that RTOs, when RTOs make decisions, they would be more FERC-like. They would actually focus on merit. They'd make a merit-based decision. I think sometimes they count heads more than they weigh merit. And if they were more FERC-like, then we'd get, better, two times removed, FERC would get better filings coming in the door that would be easier for FERC to approve, and RTOs would be reversed with less frequency.
But Joe, don't you think in part that's an issue that has to be dealt with when we have voluntary organizations in which the transmission owners have the opportunity to leave and frequently threaten to do so if they don't get their way? We've basically harmed the RTO process. So we need to find a way, I hope during this discussion and whatever outcome there is to find a way to empower the RTOs to make more FERC-like independent decisions and to reward them for doing so.
I agree, but I don't agree that they actually have the right to leave. I think under Section 205, FERC would have their withdrawal filing would be a Section 205 filing. FERC would have to make a filing under Section 205 that their withdrawal doesn't address the regional scope and configuration of an RTO and doesn't affect the transmission service provided by the RTO, which is also a public utility. And if someone is tiny, like we voted for the Louisville gas and electric withdrawal, I think that stands for the proposition: if your transition system is small enough and your departure from an RTO doesn't affect scope or the ability of the RTO to provide service, sure, you could probably leave. But if you were a core transmission owner in RTO, I think FERC could reject your withdrawal under 205. They've never said that, and so that's my inference. But I believe that's true. I'm not sure I've seen this commission say that. I don't think they have had the opportunities.
And Joe, it doesn't actually have to go that far. The mere threat of withdrawal, which we did see a lot, has people scrambling to accommodate that transmission owner. And again, I think look, if I wanted to protect my monopoly, that's exactly what I would do. But the reality is, I think we need to create structures where people are able to be independent of those kinds of undue influences. And I think part of that will be dealt with in the planning process. I think when you have a more fulsome and robust and transparent planning process, that will be a major change. But I still think that it's an inherent flaw in the structure that we have. So I commend the RTOs for trying, but again, you get those merge filings because they're trying to accommodate too many people.
We're going to move on to discussion of the gas pipeline certificate proceeding in a moment, but first I want to transition. In January, there was a decision that kind of flew under my radar when FERC granted Adelphia Gateway's request for an 18-month extension to complete their pipeline project. At the same time, the Commission announced the new policy on interventions in these sort of proceedings, And it said that it allowed intervention in extension of time proceedings regardless of the intervener status in the underlying certificate docket. Neil, you've said that this could be a pretty significant wrinkle in FERC's proceedings. You want to elaborate?
Yeah, this kind of flew under the radar, but I think it has the potential to be pretty significant. Now, on the surface, I think Chairman Glick in particular, Commissioner Clements as well, have been pretty clear, and I had numerous conversations with both of them over the years about granting late interventions and giving greater access to the commission and the ability to participate in dockets. Because the parties that tend to come in late are less familiar and perhaps have less resources. And certainly, I'm sympathetic to that. But, if we're talking here about allowing parties that weren't, or allowing entities that weren't parties to the underlying docket to come in an extension and introduce potentially new information, theoretically, you're going down the path of potentially imposing new conditions on a previously issued certificate based on new information that could be brought to bear by these parties who are intervening when they did not intervene initially. And that's something to keep a very close eye on to see if that's one more obstacle to frustrate certificates from moving forward at the commission. And so it could be just along the lines of that ethos of giving greater access to the commission. But if we're going to get into a situation where we're now imposing new requirements on a previously issued certificate in the instance where the party is seeking an extension of time, that could be hugely significant. And as the process becomes more complicated, I think you're going to see more extension of time requests. And so this has the possibility of being a really big deal. And then my final point before we totally move into gas certificates, because it ties to transmission, and I was kind of screaming this from the rooftops during my closing months at the commission, the proponents of building out transmission to bring cleaner energy sources to market, in some instances have historically been the opponents of building out pipeline infrastructure. And what I try to relay to folks is that you cannot expect that actions that are taken to frustrate pipeline development on the NGA side and put up bureaucratic and regulatory obstacles, that wouldn't apply through the FPA on the transmission side. And I think what is likely to occur here is that the proponents of transmission who may have been opponents of pipelines are going to see their own playbook run against them to frustrate potentially transmission development. And so I feel like that's a good way to transition from the conversation about transmission to the certificate policy statement.
Let's talk about that. As you're well aware, Neil, and anyone who follows FERC, Chairman Glick has been very outspoken about what he sees as FERC's failure to evaluate greenhouse gas emissions from new pipeline projects. Joe, at the technical conference last summer on potential changes to the certificate process, you questioned FERC's legal standing. What is your perspective on this? You've said that you think it was a mistake to have started.
Well, okay, there's two things there. What technical conference was focusing on whether FERC should seek to impose greenhouse gas mitigation in pipeline certificates. But the bigger issue, the comment that you just reflected on, was more a view on the certificate reform itself. That goes back to January of 2018. I think the commission issued that it was going to consider reforming the certificate policy statement. And I think that it was a mistake to initiate that proceeding, because I think when you initiate a proceeding like that, you really have to think about the end game. And you have to think about, well, where do the commissioners stand? What kind of reforms might they support? And I think just to start a process because the question's interesting wasn't the right way to proceed. Because now we look at it as, well, if you remember, this is a policy statement. What is a policy statement? A policy statement is an expression of future intent. The courts have actually compared PG&E case compared policy statements to equivalent of a press release in terms of their legal importance at FERC. Now, a policy statement, if it's going to have any value as an expression of future intent, has to be supported by the commission unanimously or by at least a supermajority. Neil would be closer to the situation than I am, but I do not see a supermajority emerging for really substantial changes to the certificate policy statement. I didn't see it in January 2018 either. So I thought this process has hit a wall, and let's compare it to SMD. It's hit a wall. Well, no, it's hit a wall. Let's forget about SMD. It's hit a wall. So then the question is, what does the commission do? One is you could seek to pound out a 3-2 policy statement that makes some really significant changes. But to me, that approach produces something that has no value. A 3-2 policy statement has no value as an expression of future intent, and it won't be taken very seriously by the industry or stakeholders. The second is put on a back burner so that it's nominally there, but there's basically no staff working on it because you don't see an end game where you can get a supermajority. To me, that's a better option than the first option. And the third option is to actually recognize that you don't need to reform the certificate policy statement. You can just apply it differently. And I thought NextEra Energy had some forward-leaning comments in the docket where we were proposing that the commission more transparently balance the benefits and the harms from a project. And that in doing so, the commission can include the physical environmental impacts of a project, old growth trees and wetlands. And conceivably, the commission could include the direct greenhouse gas emissions from a project. I think there's no legal basis for the commission to attach conditions that would require the pipeline to mitigate the upstream and downstream greenhouse gas emissions associated with the project. So I think there's 3 options. Right now, I don't know if the game plan is option 1, to pound out a 3-2 policy statement that has almost no value, or to leave it on the back burners, that it's nominally alive. But I remember Billy Tozian had a great quote years ago about a natural gas bill. He said, "I don't know if it's alive or not, but last time I cut into it, it didn't bleed." He's former chairman of the House Energy Committee. I thought, what a great quote. I haven't been able to use that for a long time. So I actually don't know how this proceeding, how alive is it? Is it actually on the back burner, or is the commission going to move ahead?
Neil, you were reading some tea leaves in the commission's recent data request to Rio Grande and Texas LNG. You want to elaborate on that?
Well, I mean, I think to Joe's point, and just to take a step backward before I get to that, I was chair. The reopening of the certificate policy statement was open for the entirety of the time I was chair. I made very clear, I thought, to Chairman Kelleher's point, for a certificate policy statement to have any value, it had to have the full complement of 5 members participating and preferably be unanimous, but at a minimum have a supermajority. And I actually, in looking back on it, I marveled at this. In the 2.5 years that I was chairman of FERC, I never had a full complement of 5 commissioners. And I do not think we were in a position to ever achieve even a supermajority compromise on how to evaluate certificates going forward. And so I agree completely with Joe's remarks that a 3-2 policy statement will have almost no value and will not be taken seriously. I think it has to, at a minimum, be 4-1 and be bipartisan to have any hope for significance or durability. There's an added variable to it as well, which is I think if it comes down 3-2 and is pounded out, either Chairman Glick, if he wishes to seek another term as chair, at the commission, or if he needs to be replaced by a successor, either way, the chairman or his successor is going to have to go before the Senate Energy and Natural Resources Committee for confirmation, and then the full Senate. And in a 50-50 Senate, as we've seen, where Senator Manchin is the decisive vote, and Senator Manchin is a staunch supporter of pipelines, I think a 3-2 pounded out partisan policy statement could create headaches there, and that's something to be considered. So that would argue for the latter approach. option 3, if you will, not pound it out, not put it on the back burner, but potentially take action and apply the new approach in individual cases. So in those 2 LNG orders that were remanded back to the commission by the DC Circuit, I think it's instructive that the DC Circuit did not vacate the certificates and seemed to indicate that there was a path forward, that the commission under my leadership didn't do a sufficient GHG analysis and didn't do a sufficient EJ analysis, but seemed to indicate that those defects were curable. And so in reading the tea leaves with these data requests, maybe that's an indication that staff and the commissioners are preparing to move forward, and might they impose some of their new views on how to approach certificate matters in those individualized cases. Again, I'm purely speculating here. My final point I'll make is, look, I tried to work with my colleagues in the Northern Natural case last spring to see if there was some kind of way to broker a compromise, at least on, kind of replacement project. And if you recall back then, we arrived at the conclusion that that particular applicant's project, its associated emissions were not significant. But we didn't spell out in the order how the commission arrived at that conclusion. And that just goes to show you the difficulty of kind of getting any kind of consensus here. I did the best I could to try and broker something to send a signal that, there would be some certificates that could get through this iteration of the commission. It hasn't seemed to work. We're starting to see a new backlog, kind of accumulate in the certificate space. And that's going to put pressure on FERC to act in some form or fashion as well.
Thanks. We got a question from, go ahead, Nora.
I just want to add, whether it is in Neil's solution, which is you could make a statement in these 2 cases, whether it's in Joe's, keep it very narrow and focus on the actual construction and operation. I don't think the option of doing nothing, having thought this through, is actually tenable, because the overhang on the market is significant, drives up cost of capital, drives away capital. And I think actually the financial discipline that's imposed by the market in the pipeline sector, unlike the electric sector, is quite significant. So I think the people who are concerned we're going to build a lot of unnecessary pipeline infrastructure is just not supported by the facts. But I think 3.2 would not be attractive, but at least it will get it done and move forward, because leaving it out there just is causing too much challenge for people who are trying to get through projects. So these are tough decisions. As we said earlier, you've got to make the tough decisions. And I just hope they can come to some resolution, keep it narrow, but get it off the table and go forward.
We got a question from Nancy Badgett from EPSA, who was responding to your point, Nora, on the voluntary nature of RTO membership. She wanted this distinguished panel to express their view on the role and influence of states today. They seem to be exerting more pressure on both ISOs, RTOs, and at FERC to view them as super stakeholders, to coin a term. Why don't you go ahead, Nora?
We had that very same conversation when we created the Office of State Relations, and we tried to open a more constructive dialogue with the states. And I do think they are important. I do think they are critical. And I think that their knowledge and their needs need to be considered. That said, it is the role of the FERC to look at the larger picture, to look at regional and national issues. And I don't think an individual state can or should be able to stop reform or projects from moving forward. I think that's not in the best interests. That's why we have a Federal Energy Regulatory Commission. And that's difficult. And I applaud this for making the point to reach out more and actually to answer the question of the late interveners. There's lots of ways to let people participate on time. I think it's a dangerous precedent. So I respect the states. I was president of NARUC, but there comes a time that you have to step back and look at the larger good.
Joe, you want to weigh in on that, or Neil?
I mean, I think when you look at FERC and state relations, it really comes down to, well, what do you think? What are you comparing it to? What's the proper benchmark? And if it's perfect harmony, then you'll always be disappointed, because there's always there really has to be some level of tension between FERC and state regulators, because they're operating, they have different duties under completely different laws protecting different customer classes. So I think it's to me inexplicable to think, why would you expect perfect harmony to come from people who actually have fundamentally different jobs? But I think FERC places great weight on the views of states, and it places even greater weight on the views of states when those views have tremendous merit. But I think FERC at times has wanted to make well, I think in the case of the RSC, the SPP RSC, states have the RSC has some kind of 205 filing right, which actually I don't think is allowed under the Federal Power Act. But there, it was approved by FERC as a settlement. And I think FERC probably shouldn't have done that, because there's a case in the First Circuit. States cannot compel a public utility to make a 205 filing. That's black letter law. And nonetheless, the RSC says, well, states can, I don't know if they can compel a 205 filing or they can prevent a 205 filing. But the RSC as a collective of states has a significant role in whether SPP, a public utility, can make 205 filing of its preference. And I actually don't think that's lawful, and I'm not sure it's good on a policy basis.
Speaking of states, and since we're broadcasting to the Northeast EBA, there's a lot of concern in New England over getting through this winter. ISO New England warned of the risk of load sheds because of limited natural gas supplies. What can and should FERC do in New England to address this issue?
I'm going to let Neil answer this one.
Look, it's a real concern, and it's something that my colleagues and I expressed over the past few years. That in sort of frustrating some of the infrastructure development and some of the issues that we had getting pipelines into the Northeast, that it could lead to a reliability crisis. And I found it particularly troubling that we had instances in which we were importing Russian LNG into Boston Harbor to meet that shortfall, and I think it's inexcusable, and it's been a challenge. Some of it has been frustrating at the state level, and in getting water permits, and it's a real issue. And we've seen grids tested now in both California and Texas in the past year, and certainly with a cold winter in New England, I don't think hoping and holding out for luck is a strategy. And I think there's real issues around energy security and safety with getting the requisite pipeline infrastructure that is needed to serve New England reliably. And again, just with the abundance of natural gas that we have in this country, to think we're importing Russian LNG to get through a cold winter in New England is just, to me, astonishing.
And I think the irony of this is, and it's we've been saying this for 25 years. The governor of Rhode Island called me Chicken Little one winter when I went up to say, you need to deal with this issue. The reality is that they rely more on oil on these cold winter days. So if you're really opposing gas on environmental grounds, what are you doing with dual fuel and oil reliance, which increased dramatically in the month of January? Sorry, Joe.
No. My only comment is pipelines that serve the region have proposed a fairly creative capacity increases, but sometimes the state, that they need support. They need some kind of contract, some kind of support from LDCs, and some of the approaches that the New England states have taken were really not viable at FERC. So I thought that was sort of a wasted exercise. And there have also been proposals to build transmission to port Canadian hydropower, and those proposals have struggled. So there have been efforts, but some of them have been kind of wrongheaded and others have been blocked.
Let me jump off on that to address some of the climate issues. As you know, Congress in the infrastructure bill once again tried to give FERC transmission backstop authority. Its previous attempt was rendered toothless by the courts. Chairman Glick said yesterday he doesn't expect many requests from utilities asking FERC to override their state regulators. Do you agree? Will FERC be able to break some log jams here?
Right now, Chairman Glick's been pretty clear, and I think Commissioner Clements has spoken to it as well, is that, that backstop siting authority is not the end all be all, and it's a tool that the commission is going to be very reluctant to use. I think if you look at the mere fact that they are working hand in glove with NARUC and with their state regulatory counterparts on this, with the forum second session of it next week at NARUC, it's a clear indication that they think the most viable path forward is to work in cooperation with the states and not run over them. I think also, if you look to the arguments that were made in opposition to some of the market reforms that the commission pursued during my tenure, the chairman was very strongly on the side of the states there, and it would be pretty tough to then turn around and roll them when it comes to transmission. And so I think at least at this juncture, and it may frustrate transmission build out because siting is extremely complicated, I find it hard to see in the immediate future the commission being in a position to where they're rolling the states here.
You addressed.
I'll just quibble. I actually don't think that the 2005 authority was rendered toothless by the courts. I thought it actually was a minor flesh wound, and the rule itself wasn't changed. The rule itself wasn't remanded. So anyway, I think it's been viable since 2009 when court decisions came down. But in part, DOE has a role in it. DOE is really not a regulatory agency. They're not an infrastructure agency. They've never successfully cited anything. And they were politically, they made a lot of political mistakes when they were acting on their part. They designated 85% of the state of Pennsylvania as a transmission corridor, and they were surprised at the pushback. And so it was like to them a third rail. They didn't want to touch it from that point on.
I would like the record to reflect that Joe wrote that language as a staffer in the 2005 energy policy. So he personally invested in it.
No, I actually started with something that was much more like the gas pipeline process. But you're right, I did have a hand in it. So I was mad that my baby was abused by the courts and by DOE. So I'm still mad.
Well, I stand corrected. So it was mismanagement by DOE then. Let's look at the one other issue. A couple of minutes we have left. Neil, during your tenure, the commission said it would be open to considering carbon pricing. Now, the New England states have failed to agree on any carbon pricing beyond RGGI. PJM states are even more disparate, less likely to go that route. New York ISO has endorsed it, but Governor Cuomo never acted on it. Is this a dead letter, or is Governor Hochul likely to embrace it in New York? Will this be an issue?
You know what? I think it's something that that the governor is going to have to deal with. I'm not going to speculate what may or may not happen in New York, but I just want to clarify what the commission did in the policy statement on carbon pricing. We made very clear that we didn't believe the record that was established gave FERC the legal authority to impose a price on carbon on RTO or ISO under 206, but that if an RTO or ISO had a state that was willing to put in a price on carbon and they brought it to the commission, that the commission could make a determination on whether it was a just and reasonable filing. And the reason I arrived at this conclusion, quite frankly, was not in a vacuum. It was, a choice between that versus the alternatives. And what I came to find during my tenure at FERC, where I was fortunate enough to have a front row seat to the conversation around decarbonization, that in the absence of any kind of federal legislative leadership on carbon mitigation, the states were increasingly going to take it upon themselves to take their own steps to decarbonize. And those policies were coming in conflict with the efficient functioning of markets. And we tried and tried again to try and get it right, and were met with fervent opposition. And so I just came to the conclusion that I wanted to see markets succeed and continue, and didn't like the idea of market participants perhaps withdrawing from the markets. So I wanted the markets to move forward, but I wanted to find a way to have efficient market functioning and kind of get away from the subsidies and the mandates and the regulations that were driving market decisions. And I did feel that a transparent price on carbon was the most effective way to go about it, given the alternatives. And I think it's possible that right now the politics around it are difficult, but I think increasingly as market participants and states start to see the inefficiencies of these other decarbonization policies, and then reliability. I mentioned earlier, I believe that some of the market decisions that are being made regarding the generation mix are political decisions. And what we saw in California last year was that certain gas plants were retired prematurely because of political decisions, and the balancing resources weren't in place, and it led to catastrophic blackouts and brownouts. And so I think a market-driven, transparent approach to carbon mitigation is a vastly superior tool to some of the alternatives, particularly when it comes to reliability. And I think over time, again, when compared to the alternatives, I think market and grid operators might see this as the best path forward.
I'm afraid that'll have to be our last word. We've run out of time. The hour has zoomed by. Thank you so much, Joe, Neil, and Nora. Nathan, let me hand it off to you if you want to close out.
Thank you, Rich, and another big thank you to all of our speakers, and to you as well, Rich, for guiding that discussion. The amount of ground that was covered was just truly staggering, and it's we're all incredibly appreciative for the insight that each of you have offered. It's going to be an interesting year, particularly with the current composition of the commission, and I think we're all looking forward to seeing how it goes and what comes out of it. So another thank you to my colleagues on Northeast Bars, the Northeast EBA, for helping me put together this event, and for everybody for joining us. Keep an eye out. We'll have some more programming coming up from the Northeast chapter soon, and I hope to see you all there.
Look forward to it.
All right. Bye, everyone.
Bye-bye.